well, for a lot of people these days, just about anyone, they're likely to have a website. That gives the voter the opportunity to go to the website and explore what the group is all about. So we anticipate submitting the legislation to the state legislature by the end of the week, and I'm sure that'll go through a process of LSC review. We've had some preliminary discussions with State Representative Mark Oakey, who is interested. We don't know yet who would actually carry the amendment, but it makes sense to us to, since there are already ongoing discussions between both houses, to actually offer it to the House and the Senate. The bill's in the House right now. The Senate Bill 8 is in the House right now, and that looks like it will be the vehicle for election reform to see if, so we can have swift consideration, make sure this is in place for November. Go ahead and add this to be a part of the bill. And I have no illusions that they may take a look at this and want to add or change a few things. But we think if you want something that really captures where the money is going and leaves us with, as far as we can see, an airtight situation, then we need to include these entities, and we need to be able to track where the money's going. And I know I said previously, when it came to Let Ohio Vote, that sunshine's the best disinfectant, but it will be in this situation as well, unless and until the Supreme Court would decide that maybe this wasn't such a good idea. Questions, Jim?
I'm interested in the provision that deals with the advanced filing of the broadcast media advertisements. Is there any other place in Ohio law where anyone has to, in advance, present their ads and explain when and where it's going to air?
The only thing similar I could give you is oftentimes when people are running for judicial offices, especially here in Franklin County, they will sign an agreement with the Bar Association committee that they will present their ad to the Bar Association for review by a committee before they air it. And when what's done in that situation is when a judicial candidate does not agree to that plan, it's not looked upon well at all by that candidate. So it's done on a voluntary basis. And what's interesting in that situation is it's almost, they're actually reviewing it to see if it complies with the Code of Judicial Conduct. But here it's just a matter of it being available to the public at or near the time that it airs.
Would it be possible, though, for somebody to look at the website and see an ad before it goes on the air, in order, if you're on the other side, to prepare a response?
Actually, good point. We could certainly write into the legislation that Secretary of State could not actually post it on the website until after the first airing of the ad. And since we have the schedule, we'd be able to do that.
Have you had any discussions yet with legislative leaders? Are they inclined to consider this kind of amendment as part of the election process?
We thought it was probably the better way to go to take this from the strongest approach and not start to find out what they'd be comfortable with or not comfortable with, because our obligation here first is to the voters, and I'm very concerned about what the experience is going to be of the voters if they're deluged with advertisements that they have a difficult time sorting out who's really making the speech. So what we have done is we have taken our best minds and we have put out a proposal that we think will give the most assurances to the voters that they can identify who's making the speech and research for themselves what those person's interests are, because this speech is being made to influence their vote.
What's to prevent someone, like, say a corporation has 5 top employees who want to give money, and they don't want to give it individually where it would be already monitored. Could they set up dummy LLCs that the public wouldn't know that it was, say, Procter & Gamble, let's give their top 5 employees, have dummy LLCs with different names. Could they be disguised in this still? I mean, go around it legally?
That's a lot of hassle for a person to do just to hide their name. When under the Citizens United case, Procter & Gamble could just write the check.
Right. But maybe Procter & Gamble doesn't want the fallout from it. Maybe they're promoting something that might not be otherwise politically popular, or it might somehow disenfranchise some of their customers. So they have their people go out and set up some dummy LLCs that are nondescript. It seems like there's a way around it already if they wanted to do it.
They could, as long as it doesn't go into the area of concealing contributions or expenditures. There still is the overall statute on concealment, and a lot of that would depend upon what kind of purpose clause they gave their LLC and how well they actually kept up the minute book and the paperwork for the LLC. Most people who go to that length aren't very good on the follow-through.
Do you anticipate your office would need more money, more resources to be able to add this function of oversight? Would you maybe be seeking appropriation also?
No, I don't anticipate that because since we've been in office, we changed the focus of our IT section so that we were outsourcing as little as possible, and we grew the developer staff to do the programming in-house. So for instance, if you take a look at Better Lives, Better Ohio on our website, that was all done in-house. So we would be able to create that functionality with the hardware software that we have available. And we have the people who can do it.
Just to make sure that I understand the nomenclature, the term independent expenditure, is that essentially electioneering communication?
It's an electioneering communication, and it's made without the cooperation, consent, or in concert with the committee that's benefiting from the contribution. This could end up making this is likely to make the Elections Commission a little busier because they're certainly, if someone felt that the independent expenditure was not truly independent, they could file a complaint with the Elections Commission. Even if we learned about it, we could file a complaint with the Elections Commission, and they would then be empowered to go ahead and investigate and hear it.
But the phrase independent expenditure is no broader than what state law means now when it says electioneering communication.
Correct.
Does your provision include any kind of effort to confirm that the expenditure is truly independent or not coordinated with a campaign, an affidavit, or some other vehicle?
Actually, at this point, no, but it might not be a bad thing to consider. And it's something I had looked at earlier, and it would be then a question of if it's a corporation, the officer of the company would be responsible for such a thing, going ahead and signing some kind of an affidavit. But the same then would apply to legislative caucus committee or political party. And it's worth considering. I expect it may be something that may come from legislative deliberation.
And the provision that says a corporation receives any state or federal funds cannot make expenditures. How far does that extend? Does that include things like a tax abatement, for example, or is it strictly just if you receive any kind of actual funding?
We were envisioning that it just dealt with the actual funding.
So a research institution that gets a grant through Third Frontier would be unable to also participate in electioneering communication?
Well, in an independent expenditure. Electioneering communication is a broader category, and among that would be a direct, would be something that a person could put out in cooperation with another committee that would then become an in-kind contribution to that committee. But this is only in regard to independent expenditures. Because, Jim, in the situation, in the first situation, if it's a corporation, it still can't make, once it would make if it tried to characterize it as an independent expenditure, but it actually cooperated with the benefiting committee, it then immediately becomes an in-kind contribution, and it still violates the law. Because the Citizens United case, despite what I've seen written in other places, doesn't allow the corporation to make the direct connected contribution to the benefiting committee.